Okay.
I wonder whether you covered any sort of legal paper trail surrounding these policies. For instance, I know the British were quite diligent about derogating from a number of the human rights due process provisions that they had subscribed to. The rules of the ICCPR derogations are just full of British derogations for certain periods for the Troubles. Was there an effort to cover their trail, so to speak, legally with these derogation practices or procedures?
Yeah, there was, in the sense, we didn't uncover anything ourselves. We weren't really looking in that sense, except for the fact that we were able to, the courts in both the Ireland versus the UK case and other attempts to litigate against these practices, they were able to discover that the government did acknowledge that there was actual policy to use the 5 techniques, for instance, which was not ever explicitly done. They clearly had tried to shield that, to hide it. But it was discovered later, not by us, but certainly that there was evidence that they had attempted to kind of cover their tracks on that.
You mentioned that you looked at things that did work and didn't work, and then we heard a lot about what didn't work. What practices, in your opinions, did work?
Yeah, that's very interesting. In particular, I think if you look at some of what was done in Iraq, and if you look at some of what General Petraeus and others have begun to suggest might be, should we look for someone in the Taliban to speak with? What we found worked was attempts at political reconciliation, attempts at reaching out to the community. First of all, stopping internment, and attempting to actually limit the abuses in interrogations, some of which continued even after the government was explicitly trying to stop those abuses from going on. But it was, we could track the violence in our article, shows steep declines every time talks are initiated with Sinn Féin and attempts to actually address some of the political problems underlying some of the violence and at least the situation that allowed violence to occur. And so when we see in Iraq the speaking or bringing into the fold the members of the Sunni uprising, that's precisely the kind of thing that worked in Northern Ireland. I think that's what General Petraeus was talking about when he said we can look at Northern Ireland and learn some things about Iraq. And it's also, it's kind of when we hear, my God, people are talking about whether or not we should engage in conversations with the Taliban, the initial reaction, I think, of all of us is, not with them. But the question is, are there people in that broader group that we can bring within the fold that makes them more committed to the process of having a peaceful government, and can it actually assist us in ferreting out those who wouldn't?
You may have covered this, and if so, I apologize. But I'm not clear as to what extent and how often martial law was imposed, and also how were the courts involved in this?
I'm sorry, it was hard for me to understand you. Could you say that again?
Yes. How often was martial law imposed, and did it work? Secondly, how were our courts, or their courts, involved in prosecuting these terrorists?
Well, it depended on what mechanism of detention was used. With internment, there was no involvement by the courts ever in the process. Ultimately, there was civilian oversight of the internment process. So for those who were interned, it was extrajudicial. For those who were arrested under the police powers, there was some involvement by the courts, but the rules for those cases were changed substantially to facilitate interrogation, even in those cases. So access to counsel was denied for different periods of time depending on the act. And it was during those time periods where the opportunities for mistreatment and interrogation would occur. And so there was some court involvement if there was a prosecution, but the initial stages and the amount of time that someone could be detained before the court was involved allowed for continued abuse.
There was also, they used what they call the Diplock courts. One of the studies was done by Lord Diplock, and the Diplock courts changed all the rules, changed the rules of evidence, changed the counsel rules, the presumption was changed. I'm sorry. And that also caused great problems in the Catholic community, in seeing that the rules were changed, so they viewed the whole British justice system as having been undermined.